Hello? Yeah. Okay. Welcome to our live podcast. This is Dr. Olu Asekun here. We welcome you again to another session. Uh, our podcast is every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 11 a.m. Eastern Time. And that is 10 a.m. Pacific Time. Oh, sorry. 1 p.m. Eastern Time, 1 p.m. Eastern Time, and 10 a.m. Pacific Time. 12 p.m. Dallas Time, Central Standard Time, 1 p.m. Eastern Time, and 10 a.m. Pacific Time. Welcome once again. Today, we are starting appeal series. That is, when cases are denied what options are available to you. So we are starting the appeal series. We'll be discussing appeal of cases denied by the immigration court. We will also be discussing appeals of cases denied by USCIS, United States Citizenship and Immigration Services. So we'll be discussing various options. It is not in every case that it is advisable to file an appeal. It is not in every case that it's advisable to file an appeal. So we'll be discussing the options available to you, whether you should file an appeal or whether you should file a motion to reopen. So we are starting the appeal series this month and this week. And today, specifically, we'll be discussing motion to reopen at the immigration court level. Motion to reopen at the immigration court level. So if you have a case that has been denied by an immigration court and you are thinking of whether or not to go and appeal, this session may be beneficial to you, may be extremely beneficial to you. So keep your questions coming. I prefer to have this as a form of question and answer session so that I will spend time explaining and addressing specific needs rather than just going on general information, because it's a very technical area of law, and I'll prefer to direct my attention on the specific questions that you may have. So we are discussing motion to reopen today. So we're starting with immigration court, motion to reopen cases at immigration court. That is the topic for today in our appeal series that is commencing today, this week. We'll continue every Wednesday by God's grace. So today we are starting with appeal, motion to reopen when a case is denied by an immigration judge. So if you have your case denied by an immigration judge, or you are ordered removed by an immigration judge after presenting your case, or you are even ordered removed in absentia, you didn't show up in court when you are supposed to be in court, and for some reason you found out later that you have been ordered removed. So the question is, what do you do? Of course, I'm going to kind of categorize it. Maybe we start with motion to reopen and in absentia order. Assuming that you are ordered removed in absentia, I think, in fact, the series that we are starting today is there's a lot of subtopics on it. I don't know whether we should spend a lot of time on motion to reopen and in absentia order. I think it would be best to do that because once we start discussing it, in order to be able to discuss it extensively, I think it's better to treat it as a separate topic. So I'm going to modify it. Today, we'll be discussing motion to reopen and in absentia order. Motion to reopen in absentia order. That is, if you have been ordered removed by an immigration judge and you did not participate in the proceedings, you did not show up in court, the question is, what options do you have? What options do you have? If you have been ordered removed by an immigration court in absentia, in which case you didn't show up in court or you are not even aware that you are supposed to be in court, and then the court issued an order in absentia against you, what are your options? That is the topic today, motion to reopen and in absentia order. Please modify the topic for today. Yeah, motion to reopen In Absentia Order. That is what we are discussing today. Now, talking about motion to reopen, usually every immigration judge has a responsibility to ensure that a respondent is served before the court will order such a respondent removed in absentia. It is a requirement of the law that an immigration judge must ensure that there is sufficient evidence in the record that the respondent was served, that the respondent was aware of the proceedings. So this is a mandatory requirement, and every immigration judge, there is no immigration judge that will order someone removed in absentia if there is no proof of service in the record, if there is no evidence of service in the record. Now, talking about proof of service or evidence of service, they are not the same thing. Proof of service is when you show that a respondent was served, and then evidence of service is when you attempt to serve the respondent. Whether that attempt is successful or unsuccessful, it does not matter. What matters is that the government, the DHS, ICE lawyers, we have to provide evidence of service to the satisfaction of the immigration judge. So once the immigration judge is satisfied that the respondent was served, or there was a legitimate attempt to serve the respondent, then the immigration judge can order the respondent removed in absentia if the respondent failed to show up in court. Now, I want to clarify this. Every non-citizen, everyone living in the United States who is not a U.S. citizen, they have an obligation, a legal and mandatory obligation, to report a change of address to USCIS or to the court, depending on their circumstances. If you are in removal proceedings and you move or you change your address, it is your responsibility to notify the court of your new address. So every respondent who is in court, or even every applicant, every non-citizen who lives in the U.S. and is not a citizen of the United States, you have a responsibility to notify immigration or to notify the court, depending on your situation, of a change of address. So if you move and you did not do a change of address, you cannot use that as a legitimate reason for the court to reopen the case. The court may not accept that as a valid reason, as a justifiable reason for the court to reopen the case. So you, as a respondent, you have a mandatory obligation to report a change of address, to notify the court or notify immigration of a change of address anytime you move. Now, this is very important. Let me explain this because this is from experience. If you are in proceedings, if you are in removal proceedings, your obligations are multiple. If you are not in removal proceedings, your obligation is only to notify USCIS of your change of address, and that you can do online. You can complete Form AR11 online if you are not in removal proceedings. You have that obligation. If you are not a U.S. citizen and you are not in removal proceedings, every time you move, you must complete Form AR11 and notify immigration of your new address. So if you fail to do this and immigration sent you a notice and you did not receive that notice, that will not be immigration's fault. And that will not be acceptable or justifiable reason for a court or even the service to reopen a case. So you have that mandatory obligation. Now, having said that, if you are in removal proceedings, your obligations are multiple. What I mean by that is that you have a responsibility to notify USCIS of your new address. Every time you move, you have a responsibility to notify USCIS of your new address. In other words, you have to complete Form AR11, change of address form, every time you move. In addition to that, if you are in removal proceedings, you have to also notify the court of your change of address. And the change of address with the court cannot be done online. So if you completed Form AR11 online, you are not notifying the court. So if the court does not have your current address, the court may go ahead to order you removed. And if you file a motion to reopen, the court may not be satisfied. The court may not agree with your justification for not providing a correct address. So the case may not be reopened, or the motion to reopen may be denied. So it is very important to understand these obligations. So it is the obligation, it is a mandatory obligation for anyone who is not a U.S. citizen to report a change of address to USCIS whenever you change your address. In addition to that, if you are in removal proceedings, you have multiple obligations. In other words, you have to notify USCIS of your new address, and you also have to notify the court of your new address. Remember, the court, immigration court, is not part of Department of Homeland Security. Immigration court is not part of USCIS. So whatever you do with USCIS does not translate to the court. So you have an obligation to report a change of address directly with the court, and also to report a change of address with USCIS. Change of address with USCIS can be done online by simply completing Form AR11. However, change of address with immigration court cannot be done online. So you have to contact the immigration court directly. You complete the change of address form and mail it to immigration court, and deliver it to immigration court. Or if your case, if you have a lawyer, your lawyer may upload it on ECAS if your case is ECAS eligible. It is not every immigration case that can e-file. ECAS is a form of electronic filing at the immigration court. But currently, it is not every removal proceedings that are eligible for filing electronically or uploading documents electronically. So if you have a lawyer representing you, all you need to do is to provide your new address to your lawyer, and your lawyer will know how to either upload it on ECAS if it is ECAS eligible, or mail a change of address form to the court, or go directly to the court and deliver the change of address form. Whichever the case may be, you have an obligation to notify the court of your change of address. If you fail to do that, you cannot turn around and use your failure as a reason for the court to reopen your case if you are removed in absentia. Now, going back to motion to reopen. When someone is ordered removed in absentia, or even if you are ordered removed normally, not necessarily in absentia, if you are ordered removed, or even if the court, after trial, deny your case, then you are looking at your option. Since we are discussing motion to reopen in a removal proceedings that or an order in absentia today. So I'm going to limit it to reopening an in absentia order today so that it doesn't cause confusion, because like I said, is a complex topic, and I don't want to be going from one topic to another so as not to cause confusion. So I will discuss it one after the other. So today we are discussing in absentia order of removal, how to reopen in absentia order of removal. Now, motion to reopen is what we call one chance. Generally, motion to reopen is a one chance thing because at the immigration court level, every respondent has a one-time option, one-time opportunity to apply for a motion to reopen. At the immigration court level, every respondent has one chance opportunity to apply for a motion to reopen. Therefore, motion to reopen is something that you really have to be familiar with the procedure, be familiar with the law regulating it, be familiar with how to put evidence together before you file it. Because once you miss that one chance, it may be difficult for you to get your case reopened. And now, when we are talking about motion to reopen, a respondent can only file a motion to reopen once. A respondent must pay a filing fee for a case to be reopened, because when the order of removal is granted, that case closes. The case is over. So if you want to reopen it, you are kind of bringing a dead case back to life. So you have to pay a fee. Now, these two conditions, because we are discussing motion to reopen an in absentia order today, an in absentia order is an exception to these two conditions. Motion to reopen an in absentia order is an exception to these two conditions. That is, it's an exception to the one-time filing of motion to reopen. It is also an exception to the filing of to the payment of filing fee. Motion to reopen an in absentia order is an exception to the filing of to the payment of filing fee. It is also an exception to the one-time rule of motion to reopen. And motion to reopen is different. Motion to reopen an in absentia order is different from regular motion to reopen, because in a regular motion to reopen, you can only file it one time. Once you file it one time, if it is denied, you don't have a second chance. Whereas in a motion to reopen an in absentia order, that one-time deadline does not apply. It is an exception. So if you are ordered removed in absentia and you file a motion to reopen and your case is reopened, if your case is subsequently denied and you decide to file another motion to reopen, because the first motion to reopen is a motion to reopen in absentia order, it will not count towards the one motion limit of a motion to reopen. So it is important to note these differences. And also, for a motion to reopen an in absentia order, no filing fee is required. No filing fee is required for a motion to reopen an in absentia order. Now, having said that, what are those considerations that the court is going to look at before a motion to reopen can be granted. As I explained at the beginning of this podcast, every non-citizen and every respondent has an obligation to provide a new address to the court and to DHS every time they move from one address to the other. So in filing a motion to reopen, you must show evidence that you actually complied with this requirement. If you move and as a result, you did not receive the notice of hearing, you have to show evidence that you actually filed a change of address when you moved. You filed a change of address with the court and you filed a change of address with DHS. So if all you did was to file a change of address with DHS and you did not file it with the court, then you will not meet this requirement. The judge may not reopen the case because you have an obligation to notify the court of a change of address every time you move from one address to the other. So if you fail to do this, the court may not reopen the case. That is one. Secondly, when you file a motion to reopen, you have to show evidence that the other party was served. That is, lawyers representing DHS lawyers, lawyers from the Office of Chief Counsel, you have to show evidence of service that they were served. Thirdly, you have to show that you had a relief or you have a relief that you would have presented if you were aware of the hearing. You have a relief that you will have presented. So even if you are ordered removed in absentia and legitimately you did not know about the hearing, if you don't have a relief, the judge is probably not going to reopen the case. So, because it will just be a waste of time to reopen the case if you don't have a relief. So even if there is sufficient evidence that you provided a new address, if there is sufficient evidence that you truly did not receive the hearing notice, the court will still not reopen the case if you don't have a relief that you are presenting. So in order for a motion to reopen to be granted, you have to show evidence, one, that you comply with the law by providing a change of address to the court and to DHS when you move. Two, you have to show that the motion to reopen that you filed, you serve the opposing party, that is lawyers from the DHS office. And three, you have to show that you have a relief that if you had appeared in court, this is the relief that you will have presented, or this is the relief that you currently have that you intend to present if the case is reopened. So if you don't have all those three things, a motion to reopen an in absentia order is likely not going to be granted. So keep the questions coming. I don't want to spend too much time on explaining this without having questions. I believe that when you have questions, we'll be able to spend a lot of time addressing the questions. Let me know if there are questions. I'm trying to log in here to see. Okay, I think I was able to log in. The first question, I was ordered removed in absentia. I was traveling and did not see the notice as they only gave me 14 days notice, and I was traveling for 3 weeks. Can I file a motion to reopen? Well, there are facts that I need before I can respond to this specific case, because if you say you are traveling and did not see the notice, the question is, before you get to immigration court, ICE will have issued a notice to appear. Are you aware of the notice to appear? Did you receive a copy of the notice to appear? Because that is the charging document. That is the document that instigates removal proceedings. That is the initiating document. So did you receive the NTA? There is a reason why I'm asking this question. If you receive the NTA, based on the case of Pereira v. Session, the Supreme Court, the U.S. Supreme Court, has stated that a notice to appear that does not have the date of hearing, the place of hearing, and the time of hearing, such notice to appear is not valid. So, to answer this question, the first clarification I need is, did you receive the NTA? If you received the NTA, did your NTA tell you the place, the date, and the time of hearing? If the answer is yes, then you cannot claim that you have insufficient notice. That is one. Secondly, if the answer is no, if your notice to appear does not have those things, that in itself is a ground to not only reopen the case, but to reopen the case and tell the court to dismiss the case, because the charging document in such case is not valid, according to the Supreme Court in Pereira v. Session. And of course, this has been contested up to U.S. Supreme Court, and the U.S. Supreme Court has made it very clear that a notice to appear must contain the date, the address, and the time of hearing. So that in itself should have given you adequate notice. The third question is, did you receive the notice of hearing from the court? Remember, the NTA is not coming from the court. The NTA is coming from DHS. In some cases, the NTA is issued by USCIS. In some cases, NTAs are issued by ICE. Whichever case, depending on the nature of what brought you to the attention of the immigration court. If, for example, it is based on asylum, then the NTA will be issued by USCIS from the asylum office. If it is based on maybe you are detained, maybe you are driving somewhere and you are arrested and detained because you are not able to provide valid evidence of legal status, in such a situation, NTA may be issued by ICE. And in some other cases, NTA can be issued by USCIS following a denial of a particular application. So, the question is, the NTA that you receive, is it a valid one? Does it have the date, place, and time of the hearing? If yes, that has given you sufficient notice. Secondly, did you receive the notice of hearing from the court? Now, going back to this question, if the notice of hearing from the court is the one that gave you 14 days notice, and of course, you are traveled prior to that, then you can file a motion to reopen. But again, you will have to tell the court that your NTA did not provide that information to you. If the NTA does not provide that information, or if the date provided by the notice of hearing from the court is different from the date on the NTA, then you may be eligible to reopen, to have your case reopened. You will have to present all this information to the immigration judge. But again, you also have to show that you have a relief, because like I said, no court will reopen a case just for reopening case. They will only reopen it in order to adjudicate your relief. So if there is no relief, it means there is nothing to adjudicate. So you still have to show that you have a relief in order for the case to be reopened. But to answer your question, depending on the fact, if the fact is similar to, it depends on your response to the issues that I've raised. If your NTA does not have the date and time and place, then that NTA itself is not valid. At least that is what the Supreme Court said in the case of Pereira v. Session. That is what the court said. So it means the NTA itself is not valid. So definitely you can request the case to be reopened and dismissed because it is based on an invalid NTA. Secondly, if the NTA has the date, place, and time, then you have to show that the date is different from the date that is contained in the notice of hearing in order to use this shortage of time as justification. However, even if you want to use shortage of time as justification, for as long as that date is not the same date in the notice to appear, then you can use that excuse, and I'm sure that the immigration court will reopen this case. Keep the questions coming in. Keep the questions coming in. Keep the questions coming in. Yeah, that is the only question we have right now. Keep the questions coming in. Since there are no other questions for now, let me continue to expatiate on this NTA. The notice to appear, that is the charging document that triggers every removal proceedings. It does not matter whether you're walking through the border or you flew in through the airport, or you are driving in through the port of entry, or you are arrested and detained and then immigration issued, they place a hold, or your case was denied and you are irrespective of how you got into removal proceedings, the only document that initiates a removal proceedings is the notice to appear, NTA. And if your NTA does not have the date, place, and time, the Supreme Court has said that such an NTA is not valid. So you cannot legally be removed from the United States based on an invalid NTA. So that is what that means. So in other words, if your NTA does not have this information, that in itself is a valid reason to use to file a motion to reopen. But if your NTA has this information, but if the date, because that sometimes happens, if the date on the has to show the date that you travel, you can also show evidence of the purpose of your trip. If, for example, you travel for employment, you can show your contract, or you can show letter of transfer, or you can show any document from your employer to show that on those particular dates you are actually outside your normal place of residence, and therefore you did not have notice of the hearing, because the date on the hearing notice is not the same date as the one you previously planned on, which is the date on the notice to appear, or that your notice to appear does not even contain the date, place, and time of hearing, which makes it invalid under pereira v. Session. So keep the questions coming. Keep the questions coming. We are discussing how to reopen a case in absentia. If you are ordered removed in absentia, what do you do? How do you reopen it? How do you prove that you didn't have notice? You didn't receive the notice. And I stated that for this purpose, you have to first look at your NTA, notice to appear, because that is the charging document. So the first thing you check on your notice to appear, did the notice tell you the date, the place, and the time of hearing? If yes, that has given you sufficient notice. If no, then you can use that not only to reopen the case, but to reopen the case and to request that the case be reopened and dismissed. So if you check your NTA. So if you are ordered removed in absentia, my advice to you, first and foremost, go and check your NTA. However, if for any reason you didn't even receive the NTA itself, in that case, what you will need to do is to request a FOIA. If you have a lawyer, tell your lawyer to request for a FOIA for you, because the FOIA information will have a copy of the NTA, the notice to appear, and then you will be able to see all these things. And like I said, in the case of motion to reopen an in absentia order, that such a motion is an exception to the regular requirement of a motion to reopen. For example, in order to reopen an in absentia order, you do not have to file the motion within 30 days, which is the normal filing if you are filing a motion to reopen with the service. You do not have to file it within 90 days if you are filing a motion to reopen with immigration court. But if your motion to reopen is based on is based on your absence, in absentia order, you can file the motion at any time. It does not have to be filed within 30 days. It does not have to be filed within 90 days. It can be filed even 5 years after. It can be filed 2 years after. It can be filed at any time. It can be filed at any time when you have notice of the order. I remember I've represented a client who was ordered removed in absentia in 1999, and then we filed a motion to reopen in 2006. That is 7 years after she was ordered removed, because it was a motion to reopen based on in absentia order. Of course, something that you are not aware of, the law does not expect you to act on something that you are not aware of. So that is why when we are talking about motion to reopen an in absentia order, it can be filed at any time. It does not have to comply with the 30 or 90-day rule. It can be filed at any time. But in order to be filed at any time, you have to show that, one, you did not receive the notice. And of course, you also have to show that you actually did not change your address, or you notified the court and DHS when you change your address. So all these are mandatory. And of course, you also need to show that the motion, when you file the motion, you serve DHS with a copy of the motion. And then you also have to present the relief that you are seeking. When the case is reopened, what relief will you be seeking? You have to include the relief that you'll be seeking when your case is reopened. So those are the things that you need in order to get a motion to reopen an in absentia order. Okay, I think we have another question. I just found out that I was ordered removed in absentia. I never received the NTA and did not even know I was in proceedings. What can be done? Actually, this fact will qualify for motion to reopen an in absentia order. So how did you eventually find out? How did you find out? So now that you know, the first thing you need to do, you need to get a copy of the NTA. So if you don't have a copy of the NTA, tell your lawyer to apply for FOIA on your behalf at the court. So when you apply for FOIA, look at the copy of the NTA, look at the allegation contained in the NTA, prepare a relief that you have, prepare a sworn affidavit where you will declare all your facts, how you did not change your address, or if you change your address, you notify immigration, and of course, you did not know that you are even in removal proceedings. So if you didn't know, you could not have even filed a change of address with the court. So you state all these things under oath. And of course, the fact that you didn't know that you are in removal proceedings, that does not take away the fact that you have a responsibility to file a change of address with DHS. So for as long as you are not a US citizen and you live in the United States, you have an obligation to file a change of address every time that you move or your address change. So you have to show that you file a change of address with DHS, or that you did not even change your address at all. Your address did not change. So you have to show those things and attach evidence of those things to your motion to reopen. And of course, you have to look at the NTA first and then make sure that you have a relief to present to the court. If you do all that, I assure you that your case will be reopened by the immigration court, and you will have an opportunity to present, to defend your case, or to present whatever relief that you have to the immigration court. Next question. I have not moved in years and did not receive a notice for a hearing. What kind of evidence can be provided to show this? Well, you have to go back to your immigration history. I'm sure that at one point or the other, you have filed some applications with USCIS. So if you have filed some form of application with USCIS at any time since you came to the US, you can now look at the address on those applications. If the address on those applications, if that is the same address where you still live, then you do not need to do anything. All you need to do is to swear to an affidavit, state that since you have been dealing with USCIS, this is the only address that you have provided, and that is the address that you are still living. And of course, you have to back it up. If you have driver license showing your address, you attach a copy. If you have mails that you have received in that address, you attach copies. And you now, the burden will now shift to DHS. They will have to show that address that they have on record, that they serve you through that address or attempted to serve you through that address. The burden will shift to them. But if at any time you have now moved, that is when it becomes problematic. Because, like I said, if you file, let's say you got married to a US citizen who filed from I-130 on your behalf, maybe that I-130 was denied, and maybe at the time, because of the policy of the government in power at the time, maybe no NTA was issued, nothing was done, case closed. You never did anything, USCIS did not do anything. Maybe years later, you divorce, you remarry. Remember, what immigration will still have on their record will be that your address that you provided in the I-130-485. Now, if your marriage failed and you remarry and you move to a new address, even though you don't have a pending case, you still have an obligation to notify USCIS of your new address whenever you move, because you are not yet a US citizen. It is only US citizens that are exempt from this obligation of reporting a change of address. For as long as you are not a US citizen, whether you have a pending case or not, you have an obligation to notify USCIS whenever your address change. So if you did not notify them when you move, then that becomes problematic. However, based on the fact that you sent, if you have been in the same address since your previous filing with immigration, if your address has been consistent, all you need to do is to swear to an affidavit, attach proof of address, attach evidence that you receive mails from other vendors or from other activities that you do, utility bills, water bill, electricity bill, your copy of driver license, current and expired one, just to show consistency in your address, that you have never done a change of address, you have never moved. That is all you need to attach to the affidavit, and I'm sure that the court will reopen the case, because once you do that, the burden shifts to DHS. DHS will now have to show to the court how you are served. Let me say this, because I've also seen this from experience. Sometimes certain people are served with the NTA in person. Some people may have been served in person with the NTA, and then maybe for years the NTA was never registered. And then the person didn't even know that there is an NTA among the document that was received. For example, maybe you apply for asylum and you are interviewed at the asylum office, and at the end of the interview, the asylum office sent you what is called a referral notice. Attached to that referral notice is an NTA. Now, notice to appear. Now, for some reason, maybe the asylum office or DHS, for some reason, for years, maybe they didn't file the NTA with the court and you forgot about it. That does still not prevent you from doing a change of address if your address changed after you filed the asylum. You have that obligation. I've seen a situation where NTA was issued. In fact, I have a case where NTA was issued in 2012, and that NTA was never filed at the immigration court until 2022. That was 10 years after. 10 years after. So, if the address that the client had at that time is no longer the address where the client is living today, the client may not have received the NTA. But again, because that client is not a US citizen, the obligation to do a change of address rests with the client. But luckily, in this particular case, this client, when he received the NTA in 2012, he brought the NTA to my office, and of course, our services were engaged. So we were waiting for DHS to file the NTA in court since 2012, and they never did. And of course, if the NTA was not filed, as lawyers, we cannot enter appearance in court because the court will not even have knowledge of the case. It is when an NTA is filed in court, that is when the court begins to process the case. That it is the NTA that gives the court notice of the case, of the existence of the case. So in this case, The NTA was never filed with the court. But because we have been engaged, we keep checking every month. We keep checking whether the NTA has been filed. We keep checking. For the past 10 years, we check every month. And guess what? In 2022, we discovered that the NTA was filed. So as soon as we discovered that the NTA was filed, we also filed our appearance in court, notifying the court that we represent this client. So I'm sure that if the client did not retain us, if the client had moved, it would have probably missed the NTA. Of course, that is assuming that the client failed to do a change of address with DHS, because if the client move and file a change of address with DHS, if the court send the notice to a wrong address, DHS has an obligation to notify the court that the respondent address has changed and then provide a current address to the court, and then a new notice of hearing will be forwarded to the respondent's current address. But if the respondent failed to notify DHS of a new address upon moving, then the respondent will have the burden to show why the case should be reopened, even though it's an in absentia order of removal. So, next question. Hello, sir. This is not directly about being removed in absentia, but I was meant to have a hearing before EOIR, and they canceled the hearing and did not notify me. Why would they do this? Well, I can't answer to why they would do it or why they didn't do it. But what I can tell you, based on my experience, is that no court, and I repeat, no court will order a respondent removed in absentia if there is no evidence on record, evidence of service on record, or evidence, either proof of service or evidence of service must be on record. Proof of service in the form of, okay, this is the proof that the notice was delivered to this person. The judge must have it on record. Or evidence of service. Now, evidence of service is different from proof of service. Evidence of service may be in the form of, okay, this is the address that we have. We mail this document to this address by certified mail. The post office returned it as undeliverable. That is evidence of service. Once the court sees either the proof of service or evidence of service, then they will go ahead and order a respondent who failed to show up ordered such a respondent removed in absentia. So I am sure there is a form of evidence in the record, especially based on this fact. If you have been attending a court, a hearing before, if you have previously appeared in court before and your case was reset or the hearing was cancelled, then it is either this hearing that was cancelled, can you please clarify this? This hearing that was cancelled, was that your first hearing? Because if that was your first hearing, it means that the judge has not had the opportunity to obtain your current address. But if that was not your first hearing, every appearance at immigration court, whether you appear pro se without a lawyer or you appear with a lawyer, the first thing that every immigration judge does is to ask the respondent to confirm the address. That is the first thing. I can tell you that authoritatively. No judge will conduct a removal process, proceedings, without confirming the respondent's address. That is the first thing. It does not matter whether you are represented by a lawyer or not. That is the first thing that the judge will confirm. So once the judge confirms your address, if the case was cancelled, a notice of hearing will be mailed to the new address. A notice of hearing will be mailed out. And like I said, based on my experience, no judge will order anyone removed in absentia if there is no proof of service or evidence of service in the record. So it is either there is proof of service in the record or there is evidence of service in the record. Another thing that you need to clarify, whoever sent this question, another thing you need to clarify is, even though your previous hearing was cancelled, before that cancellation, were you represented by a lawyer? Did a lawyer enter appearance? Because if you are represented by a lawyer, the notice of hearing will go to that lawyer. The notice of hearing will go to that lawyer if you are represented by a lawyer. It doesn't matter whether the hearing was cancelled or not. Once a lawyer enters appearance, every notice, every communication in a removal proceedings goes to that lawyer. So it may be that the notice of hearing was mailed to your lawyer, and maybe you had a communication challenge with your lawyer. Either the lawyer didn't tell you or the lawyer attempted to reach you and was not able to, even though if a lawyer attempted to reach you and not, of course, the lawyer will have documentary proof. In our office here, if we attempt to reach a client and we are not able to, we will write a letter and mail out with certified mail to such a client. If we have the client's email, we will send an email to the client. If we have the client phone number, we will send a notice. We will call the client. All these things will be documented, because a lawyer may be subject to a complaint. A complaint may be filed with the state bar against the lawyer if the lawyer received the notice of hearing and did not communicate it to the client. So you may want to check this out. If your lawyer is the one that received the notice and did not communicate it to you, then that may be another challenge right there. That may be a basis for a motion to reopen an in absentia order based on ineffective assistance of counsel, matter of Lozada. So you want to look at all the options before you file your motion to reopen. Okay, next question. Is there a way to check hearing date other than receiving notices in the mail? Yes, there are several ways to check. There are several ways to check. There are immigration court information system. There are phone numbers to call to check if you are in removal proceedings. You can also check online. If you have your alien number, you can go through the EOIR website to check if you have your alien number. And you can also call the immigration court information system. That number, let me see if I can get you that number, the immigration court information system. Okay, the immigration court information system, you can call 1-800-898-7180. 1-800-898-7180. If you are in removal proceedings and you want to be sure whether or not your case has been reset or you have a pending case or the date that your case is coming up, you can check on the Immigration Court Information System. That number is 1-800-898-7180. 1-800-898-7180. And I believe that number is also posted on the screen, so you can check. Immigration Court Information System, 1-800-898-7180. So if you are in removal proceedings, you can check. You can check to find out the date that your case is coming up, or the time, or even the judge that is handling your case. You can check all these things online or through the phone system, Immigration Court Information System. Okay, next question. Keep the questions coming. Please keep the questions coming. The next question: is there a way to check hearing date? Oh, I think that's the last one I just answered now. Okay, that's the question I just answered. Okay, keep the questions coming. Keep the questions coming. Keep the questions coming. We are discussing removal in absentia. When you are ordered removed in absentia, what are your options? You can file a motion to reopen. But what are the requirements of a motion to reopen? In order to file a motion to reopen, every non-citizen, every non-US citizen has a mandatory obligation to notify DHS of a change of address every time you change your address. So that is the first requirement. You have to show that you actually either did not change your address, or you have to provide evidence that you actually notified DHS when your address changed. If you file a change of address online from AR11, you will receive an email which you can use as evidence of a change of address. If you file a change of address by completing and mailing out from AR11 to DHS, you will also have evidence of mailing. You can also use evidence of mailing as proof that you file a change of address to USCIS. Of course, if you send anything to USCIS with regular mail, you are not going to have any evidence. So it is always advisable, when you are dealing with USCIS, when you are dealing with DHS, always mail document either with certified mail or at least with something that is trackable. You have to be able to show evidence of tracking. And when you mail it, it is advisable, track it and print out the evidence of delivery, and then attach it to your motion to reopen. Show that, okay, I completed from AR11 on January 6. Here is a copy of the form. I mailed this form to USCIS at this particular address. Here is a proof of delivery. So you track the delivery, you print it out, you attach it to the AR11, and you attach it to your motion to reopen, and I guarantee you your case will be reopened if you follow those requirements. Okay, I have another question. If someone is in the hospital and misses a hearing notice, can you use that in a motion to reopen in an absentia order? Certainly, yes, you can use it, but you will have to attach a medical report. You have to show medical report to show that on that date you are actually in the hospital. Of course, if someone is sick and you are not able to attend a court hearing, yes, you can use that as a legitimate reason to request that your case be reopened. Yes, you can use that. Simple answer to that is yes. But you have to include medical record to show that you are actually in the hospital on that day. And of course, that will not be a hospital visit. It will be hospital admission. It cannot be hospital visit. If it is hospital visit, if you visited an hospital based on doctor's appointment, that cannot override a court hearing, except you have previously informed the court of your doctor's appointment and the court has given you an approval to not show up in court. Of course, if you have a doctor's appointment, you can use that as evidence to as a reason to tell the court that, oh, on that day, I won't be able to appear because I have a previously scheduled doctor's appointment. But that has to be done before the absentia removal order. You cannot use that after the case has been, after you have been ordered removed. You cannot do that. You use that. The only one you can use is if you are on admission on that day. Yes, you can use that to request a removal order to be reopened, especially order in absentia. Okay, the next question. If I move out of state and notify the court, as you mentioned, does that automatically change the court hearing to a location near me? No, it does not. If you move, you have an obligation to notify the court and to notify DHS of your change of address. That does not trigger a change in venue. If you want your case to be moved to the new location where you are, you have to file a motion for that to happen. Such a motion is called motion to change venue. So you will have to file a motion for that to happen. And let me tell you, not only is your move not automatic, you may even file a motion for change of venue and it can be denied. In fact, I have done that in the past. I've seen judges where a motion to change venue was denied. The judge, rightly or wrongly, in my opinion, wrongly, but the judge may believe that he was right. The judge believed that we were filing the motion to change venue simply to waste time. That was the judge's position, and he denied the motion to change venue, despite the fact that we provided sufficient evidence of a new address, including AR11 change of address. So the fact that you file a motion to, the fact that you file a notice of change of address, that does not automatically change your venue. I've also seen situations where, although client moved, and of course, respondent also notified the court of the new address, I've seen situations where even the client themselves, they prefer their case to stay at the previous court where the case is pending. Maybe because of the individual judge who is handling the case, maybe because of the judge's reputation, maybe because of the workload in the area where the case is pending, maybe because of some other factors. I mean, I've seen situations where client insisted that, look, although I've moved, I've done a change of address, but I want my case to remain in this particular court. So it is not automatic at all. It is not automatic. So if a case is going to be moved from one immigration court to another immigration court, a motion to change venue must be filed. And of course, for motion to change venue, there are other eligibility requirements. As I said, the motion itself is not automatic. There are other things that has to be done in order. For example, if your case is pending and you have not even appeared in court at all, or you have appeared but you have not had the opportunity to plead to the NTA, no judge will grant a motion to change venue. No judge will grant it. Before a change of venue motion can be granted, the respondent must have pleaded to the notice to appear. That is a regulatory requirement. So the fact that you have moved, the fact that you have requested a change of address, all that is not automatic. Your change of address can still be denied. So in a situation where you have moved and you want your case to be transferred to another immigration court close to you, and you have not pleaded to the NTA, my advice to you or to your lawyer in such a situation is to do what is called written pleadings. You do written pleadings. If you do written pleadings, then the judge will grant your motion for change of venue. Please keep the questions coming. Keep the questions coming. Okay, another question. If someone is filing a motion to reopen an in absentia order, if filing a new relief, which should be filed first, the motion or the relief? Actually, both should be filed together, both the motion and the relief. If you have already been ordered removed in absentia, there is nothing to file. You don't have a pending case, so you cannot file any relief. So if you are filing any relief, the court will not even look at your relief, because they will not even accept it for filing, because there is no pending case. For you to file any form of relief, you have to have a pending and active case. So if you are ordered removed in absentia, that closes your case. The moment the court issued the order, your case is closed. So there is nothing pending. So you cannot file any form of relief. If you take any form of relief to the court, even the court will not accept it from you. They will not take it, they will not take it from you, because it simply means that you don't have any pending case. So before you can talk about filing any relief, you have to file a motion to reopen first. So usually what you do in such a situation, in your motion to reopen, you indicate what relief you will be seeking when the case is reopened. Let's say your relief was to apply for defensive asylum. So in your motion to reopen, you will state that I'm filing this motion to reopen not because I want to waste time, but because I did not receive the notice of the hearing. And of course, you attach all the evidence that you provided a change of address, or evidence that you did not move at all, you did not change your address, and you did not receive all these things. And you also state in your motion that there is no reason for you not to appear in court, because if you had appeared, you will have applied for the relief of defensive asylum. Now, you are requesting the court to reopen this case to give you an opportunity to apply for defensive asylum. So you have always had this relief, and there is no reason for you not to appear in court. You intend to pursue this relief, and this is what you are doing. Now, you can now attach a copy of the application for asylum along with your motion to reopen. That is the way it is done. And in such a situation, the judge will probably grant your motion. Keep the questions coming. Keep the questions coming. We still have a lot of time. We still have about 40 minutes. So keep the questions coming. Keep the questions coming. Let me be sure I've not missed any question, but I don't think so. No, I've not missed any questions. Okay, keep the questions coming. So as I explained, even if the motion, if the order is an in absentia order, a motion to reopen is not automatic. In order to reopen an in absentia order, certain things must be present. You must show evidence that you actually did not change your address, or you change your address and you notify DHS of your new address, and you also filed a motion, a change of address with the court. In addition to that, you show evidence that you did not receive the notice. In addition to that, when you file the motion, you must serve the opposing party, which is DHS attorneys. And of course, in addition to that, you must show that you have a relief that you will be applying for, or you will have applied for if you had the notice and you intend to pursue this relief. And then you can show what the relief is or attach a copy of the relief to show that it is a valid relief, and you are not filing the motion to reopen in order to waste time or in order to justify your own non-compliance with the regulations. Okay, new question. I was ordered removed in absentia, but I'm now married to a U.S. citizen and have an approved I-130. Is it possible to get the case dismissed? Well, the answer is yes, but I'm curious. I want to ask you, I need you to clarify something, because if you are ordered removed in absentia and you married a U.S. citizen who filed an I-130 on your behalf, were you invited for interview? Because normally, I tell you, 99.9, in fact, 100% of the time, if you have a removal order and you show up for interview, you will be arrested at the interview. So, were you interviewed, or was this an I-130 that was approved without interview? Because with a removal order, if you appear at USCIS office for an interview, you will be arrested. If you have a removal order, you will be arrested and detained. So that I can tell you 100% of the time, you will be arrested and detained. So for you to have I-130, I'm assuming that the I-130 was filed and then approved without an interview. Now, having said that, yes, now that you have an approved I-130, you still have to file a motion to reopen, because immigration does not even have jurisdiction over your green card application. You cannot get green card for as long as that removal order is pending. Is there. You cannot have green card. Statutorily, immigration does not have jurisdiction. They don't have legal authority to even review your application for green card. So the only thing you have to do is to file a motion to reopen based on lack of notice. Again, the fact that you have I-130 approved does not mean that the motion will be granted if you cannot demonstrate that you actually did a change of address, or that the non-appearance is not you did not intentionally flout the order of the court. Because you see, America is a country of law. In this country, laws are respected and nobody is above the law. So if the court asks you to come on a particular day, if you did not show up, you have to justify why you did not show up. The fact that you have I-130 approved, that is not a justification why you did not show up. So before your case can be reopened, you have to show that justification. What was the reason why you did not show up? You did not show up because you didn't receive the notice. You didn't receive the notice because, despite the fact that you provided a new address, USCIS still mailed the notice to the wrong address. USCIS, I'm not defending them. They do that a lot. You do a change of address, they'll just look at the application when you file it, you look at the address there, and then mail the notice there. But many times, such notices will be returned and as undeliverable because the post office is not allowed to forward immigration documents. So once you are no longer in that address, such a notice will be returned to USCIS as undeliverable. And usually, when notices are returned, USCIS will go back and look at your file. If they now realize that you have done a change of address, they will now resend the notice to the new address. They will resend the notice to the new address. But usually, the court does not do that. The 8 out of 10 times, if you do a change of address with the court will have the correct address. 8 out of 10 times they will have the correct address. But USCIS, probably 5 out of 10, they will still send it to the wrong address. Okay, keep the questions coming. I think I've answered this last one. That's the one that I was ordered removed in absentia, but I'm now married to a U.S. citizen. Yeah, so go ahead and file your motion to reopen, but you still have to attach evidence that you received you did not receive the notice, and of course you did not move, or you did not you did provide a change of address, but USCIS did not follow it, or maybe something that made it impossible for you to appear, like the person who asked the question about medical ground. Maybe on the day that you are supposed to appear in court, on that day you are sick and you are admitted at the hospital. Of course, you have to attach evidence of medical record or obtain letter from your doctor to show that you are on admission on that day, and you can use all that. And now, of course, based on your I-130 approval, that shows that you have a relief of adjustment of status. So you also present that, and it is also advisable to go ahead and file the adjustment of status application with USCIS, obtain the receipt, and attach a copy of the adjustment application to your motion to reopen. And of course, you have to serve a copy of that motion to reopen to the DHS attorneys. So that is the way to go in such a situation. Next question, we have new question. Keep the questions coming. We still have about 30 minutes to go, so keep the questions coming. Next question. If I do not qualify for a motion to reopen an in absentia order, is there anything else that can be done? No, there is nothing that can be done, because if you do not reopen your case, it means that the removal order becomes final, and of course, the order will be implemented. Now, let me be sure I'm getting this question correctly. If I do not qualify for a motion to reopen an in absentia order, is there anything else that can be done? Remember, we are discussing motion to reopen an in absentia order today. We are still going to discuss normal motion to reopen that is not attached to in absentia order. In absentia order is when you did not receive the notice of hearing. That is what we are discussing today. But regular motion to reopen, we are going to discuss that next week. We are going to discuss regular motion to reopen. The reason we are separating it is because the requirements are different. The legal requirements are different. The payments are different. The procedure are different. The timelines are different. There are a lot of things that are different about it, and I didn't want to discuss both of them together because it will cause a lot of confusion. So that is why we are separating it. So for today, we are discussing motion to reopen an in absentia order. As I said earlier, there are only 3 requirements for in absentia order for it to be reopened. You have to show evidence that you did not receive the notice of hearing. And of course, in showing evidence that you did not receive notice of hearing, you also have to show that you comply with a mandatory obligation for non-citizens, which is an obligation to do a change of address whenever you move. Every non-citizen, every non-US citizen living in the United States is required by law to provide a change of address every time your address change. So if you are in removal proceedings, You provide the change of address to DHS, and you also provide it to the court. In providing the change of address to DHS, that you can do online. All you need to do is to complete Form AR11. You can complete it online. Once you complete it online, you will get an email confirmation. You can always use that as evidence that you comply with that requirement. You did a change of address. However, that one you did online, that one you completed online, AR11, that does not go to the court. The court and DHS are not the same. So you still have to file a separate one with the immigration court if you are in removal proceedings. So if you comply with that, then you can use all this evidence as evidence that you did not receive the notice. Now, in addition to that, your motion to reopen, because it's a motion, it's an order in absentia, it does not require filing fee. No fee is required. Again, when you prepare the motion to reopen, you must serve the opposing party, that is the DHS attorneys. They must be served with a copy of this motion to reopen. In addition, this motion to reopen must state what relief you are seeking. You must present a relief, because the court cannot just reopen your case without any relief. It does not matter whether you received the notice or you did not receive the notice. If an order has been given, order ordering you to be removed from the United States, if you want the order to be reopened, you must state what relief you will be seeking. So those are the requirements for motion to reopen an in absentia order. And again, because this is an in absentia order, it can be filed at any time. It can be filed 1 month after, 10 months after, 1 year after, 5 years after, even 10 years after. There is no time limit if you are filing it based on non-receipt of notice. If you are filing it because you did not receive the hearing notice, such a motion can be filed at any time. It can be filed at any time. Again, a motion to reopen an in absentia order does not count towards the numerical limit of a motion to reopen. A standard or regular motion to reopen has a statutory limit of 1 chance. You can only file it once. But a motion to reopen an in absentia order does not count towards that 1 time. So these are the basic differences between a motion to reopen an in absentia order, and of course, when we go into regular motion to reopen, you will see the differences and you will understand why we are not taking the 2 topics together today, because we don't want to cause confusion. So that is why we are limiting ourselves today to motion to reopen an in absentia order. Okay, next question. I have an attorney and he keeps telling me that I need to appear or I will be ordered removed in absentia. I thought the attorney could attend the attorney on my behalf. Is my attorney right? Of course, your attorney is right. Your attorney cannot appear on your behalf. Your attorney can only appear with you. The attorney cannot substitute you. The only time the attorney can appear alone without you being there is if you have previously sought and obtained approval of the court for your absence. We do that. If there is a valid reason why that date is not convenient for you, but your attorney wants to proceed anyway, or the court wants to proceed anyway, your attorney can either make an oral motion or file a written motion for you to be excused during your hearing. Usually we do this when we have a dependent, when we have a respondent who have dependent, maybe children who are supposed to be in school, or children who are supposed to be having an exam, or something that is supposed to happen on that day. So your attorney in such a situation will have requested by motion, either oral or written, that the court should excuse you on the next hearing date. So if your attorney sought and obtained the approval of the court, then the court cannot order you removed in absentia once your attorney appears in court. And again, there are also a few exceptions. Even if there was no prior notice, if there is a valid reason for your absence, your attorney can appear in court and notify the court of the legitimate reason why you are not present. The only challenge is that in such a situation, the next time you have to go to court, you must go with evidence that corroborates what your attorney told the court. For example, if your attorney appeared alone and informed the court that you are not able to come because you are on admission in the hospital, of course, the court will excuse your absence. But at the next hearing date, your attorney will have to submit medical report to actually confirm that on that date you are supposed to be in court, you are actually on admission at the hospital. So your attorney is right. You have to be in court yourself. The attorney cannot substitute for you. The attorney can only appear with you. So if you are not there, then there is nobody for the attorney to represent. Next question. Where do you file the motion to reopen an in absentia order? Of course, you file at the court, the specific court that gave the order. You cannot file at a different court. You have to file at the court where the order was given. It does not matter whether you still live in that jurisdiction or not. Even if you have moved away from the jurisdiction, you still cannot file where you live. You can only file at the court where the order was issued. When I was talking earlier, I referred to a client who was ordered removed in absentia in 1999, and we didn't get to know about it until around 2006. Of course, in 2006, when we became aware of that order, the client was already living in Texas. He was living in Dallas, Texas. Now, the order, the removal order in 1999 was issued by the court, by the immigration court in Detroit, Michigan. So, even though the client was already living in Dallas, Texas in 2006, in fact, has been living in Dallas since 1999, but because the order came from Detroit, Michigan, we had to go back to the immigration court in Detroit, Michigan to file the motion to reopen. So you can only apply for the case to be reopened from the same court that issued the order. Even if the judge is no longer there, the court will assign it to a different judge, but it has to be the same court where the removal order was issued. Next question. If I file a motion to reopen an in absentia order, can I still be arrested or removed while the motion is pending? No. If it is an in absentia order, you cannot be arrested, because once you file the motion to reopen in court and the court accepted your filing and they stamp your copy, it serves as a motion to how do I explain it? It serves as a stay. It serves as a stay of execution. So that order cannot be executed until after your motion is adjudicated. So a motion to reopen an in absentia order, once it is properly filed, it serves as a stay of execution of that removal order. So you cannot be arrested. So all you just need to do, the copy that was stamped by the court accepting your motion to reopen, take a copy along with you wherever you go. If anybody attempt to arrest you, just tell them that you have a pending motion to reopen. If they tell you they are trying to implement a removal order, remind them that you have filed a motion to reopen which served as a stay of proceedings of that removal order. Or just call your lawyer and your lawyer will know exactly what to do. But I can guarantee you, ICE will not arrest you. That is one of the reasons when I was stating the requirement, remember I stated that you have to serve the opposing party. You have to serve the DHS. That is one of the reasons why you have to serve them, because the filing, a properly filed motion to reopen an in absentia order, operates as a stay of execution. And remember, it is ICE that arrests people. USCIS does not arrest people. Only ICE arrests people. ICE is Immigration and Customs Enforcement. They are the one that enforce court order. So you have to serve them. So if you file a motion in court and you did not serve them, then that motion is not properly filed and you may still be arrested. But upon the filing of a properly filed motion to reopen an in absentia order, it serves as a stay of proceeding and stay of execution, and you cannot be arrested. Next question. Please keep the questions coming. Keep the questions coming. I was supposed to be in court for a hearing, but was late. I showed up, but I was really, really late and ordered removed in absentia. Is appearing late a reason to file a motion to reopen? Well, it's not a reason by itself, but it is one of the things that the court will consider. Especially if you have evidence that you actually showed up late. Because remember, the judge may not even know that you show up after. To be honest with you, if you show up late and you are ordered removed in absentia, although it is an in absentia order, I will advise you that in such a situation, time will be of essence. Time will be of essence, because if you claim that you came to court but you came late, that means on that same day when the order was issued, you had notice. Because if you came late, the clerk will have told you, or maybe the registrar or whoever is at the window, they will have told you that, oh, your case has already been adjudicated, you have been ordered removed in absentia. You will have received that notice that same day. So, time may be of essence. If you want the court to consider your lateness favorably, to be honest with you, for me, if I have a client who came late and was ordered removed, I will, in absentia, I will file the motion to reopen the same day, or at most within 24-48 hours, to show that this is just a matter of lateness. Of course, your motion will be accompanied by sworn statement, affidavit, explaining your lateness. I mean, maybe there was an accident on the road. Maybe there was a problem with your vehicle, something that is beyond your control. Of course, having problem with your vehicle, that may not be something beyond your control, because if you had a problem with your vehicle, you abandon the vehicle and take a taxi or take a Uber or a bus or train. I mean, you cannot use that. You can't say, oh, I had a flat tire on the way. oh, my car stopped running. No, that will not be sufficient. Park the car, take a taxi, take a Uber, and go to court. When you are done with court, you come back to fix your car. So that will not be a valid reason. But if for any reason you got into a major traffic, yes, try to go on Google to find out the cause of the traffic and print out that page. I mean, thank God for technology. If there is a major issue, it will be in the news. It will be on Google. Google it, print out that page, attach it to your affidavit to explain what happened. Let me give you an example, a life experience of something that happened to me last month. I went for a case in San Antonio, Texas. It was this traffic. This train was blocking the way. Of course, there were other vehicles behind me. I couldn't turn back. Even before I got to that position, when I saw the initial traffic, I tried to look for other alternative routes. But unfortunately, this train was so long that it affected every single road that led to that court. So I called the client. I'm in this traffic. We still have time. Hopefully, I'll be able to get out before the hearing time. The hearing time was getting close. 20 minutes, 10 minutes. When it was 10 minutes, I told the client, go inside the courtroom, tell the opposing lawyer, let the DHS attorney know that I've been in this traffic. In fact, I took a picture of the train and all the traffic around. I took picture and I sent it to my client. Show it to them. Let the opposing lawyer know. Go to the window. Talk to the clerk of the court. Let them know what is going on. I've been in this traffic now for 40 minutes. I mean, there's really nothing I can do. I cannot fly. I cannot, there is no other alternative route to the court and everything. Okay, it was hearing time. I was still in the traffic. So, of course, they told the judge. The judge was understanding. The judge decided to wait for me. Of course, at this stage, the client was panicking because at a stage, the judge came back, asked for me, am I there yet? The client said no. Of course, I was communicating with the client. Eventually, I was able to, the train moved and I was able to get to the court. Now, why am I referring to this? The moment I started explaining to the judge why I came late, the judge said that, oh, that is something that everybody knew about. That even, the judge said, even me, I was in that same traffic about a few days ago. So that gave me some form of relief. So what are we saying here? What we are saying here is that if there is a reason why you are late, find a way to document it. Find a way to document it. And once you document it, file your motion to reopen on time. Even though I explained earlier that motion to reopen an in absentia order does not have time limit. It could be filed even 10 years after, it doesn't matter. But if your reason was that you came to court late, that means that same day you had notice of the motion. You have notice of the removal order. So you cannot come back 3 months later to say that, oh, on that date, I was actually in court. I just came late because of this. No, you cannot do that. If you had notice on that same day, time will be of essence. If I were you, I will file the motion within 24 to 48 hours. Then and present evidence of what happened on the way that caused your lateness. And I'm sure that with such detail, the judge probably will reopen the case. Next question. I was ordered removed in absentia and I just decided to leave on my own and I'm in my home country. Can I file the motion to reopen along with a consular processing case? No, you cannot. If you are ordered removed in absentia and subsequently you left on your own, it means that you have complied with the order of the court. In absentia order simply means that you should be removed from the US and voluntarily you have left, you have removed yourself. So there is nothing to reopen. You cannot reopen the case anymore. That case is closed. Now, talking about consular processing, that is a different ball game altogether. If you have a relief that allows you to consular process, yes, you can apply for that. Your removal order will give you a 10-year bar. If you have been ordered removed, that means you cannot come back to the US for 10 years. So that will give you 10-year bar. So you can do your consular processing after 10 years. However, there are still some exceptions. There are some waivers that you can apply for if you meet the requirement. So you can apply for the waiver of the 10-year bar if you have the relief. Let's say you are married to a US citizen who filed I-130 petition for you, but because you are now outside the US, you will be eligible for consular processing. But because you have been removed, either you left on your own but the removal order is there, that gives you 10-year bar. But you can apply for a waiver of advance permission to re-enter the United States. So you can apply for the waiver and then you do consular processing and you come back to the US. But you cannot go back to motion to reopen. There's nothing to reopen. The order has been given, and when you left, it means the order has been implemented. Case closed. That case is gone forever. You can start a new one. You cannot reopen that one because that order has been implemented when you left the country. Well, I guess that's the last question for now, but keep the questions coming. We still have about 10 more minutes to go. If you have other questions, I promise I will still answer them within the next 10 minutes. I will answer them. But remember to always join our podcast every Wednesday. Remember to always join us every Wednesday at 12 p.m. Dallas time. That is a Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. And of course, that is currently 6 p.m. Nigerian time for those who are joining us from Nigeria or from West Africa. I believe that West African time is the same. I'm not 100% sure, but I guess they are the same. But it's using Nigeria, it is 6 p.m. Nigerian time. So join us every Wednesday. Remember to subscribe to our channel so that whenever we go live, you get notification. Again, I always say that when you get this free information, the only thing that you can do to encourage us is to invite other people. It is not good to be selfish. We are providing this information free of charge. It is only good and fair if you share this information with other people, because the reason we are doing this is to provide information, because even the Bible says that our people perish for lack of knowledge. We have seen a lot of cases. We have seen things, and we continue to see it, that mistakes that people make, simple mistakes, avoidable mistakes, avoidable errors. So the only thing we are doing is just contributing our own quota in preventing our people from making these mistakes. After all, majority of the people in this country, we are all immigrants. It does not, except you are red Indian, except you are the descendant of a red Indian. Everybody in this country is an immigrant, including the president. If he's not directly an immigrant, his parents are. If his parents are not, his grandparents are. If his grandparents are not, his great-grandparents are. We are all immigrants. And that is why we are providing this free information to prevent people from making avoidable errors. So, the only thing you can do to show appreciation is just to share this information with other people. Let other people also join us. Let other people also benefit from this. It is our pleasure to continue to do this for as long as Jesus tarries. Again, we still have about 7 minutes. If we have questions, I will answer them before we go. Okay, a question just came in. What happens when the motion to reopen an in absentia order is granted? Of course, your case came back to life. I mean, what would have happened if you are not ordered removed in absentia? Usually, when you have a notice to appear, when a hearing is set, usually master hearing, you go to court, probably with your lawyer. The judge will ask you, did you receive the notice to appear? If you acknowledge it, the judge will ask you, how do you want to plead to the allegations in the notice to appear? So, if you have not previously pled to the allegation in the notice to appear, when your case is reopened, when the motion to reopen the in absentia order is granted, your case came back to life, the court will reset the case for a master hearing. So when you go for the master hearing, the normal thing is what the judge will still do. The judge will ask you, did you receive the notice to appear? If yes, how do you want to plead to the allegations in the notice to appear? So you usually the notice to appear will tell you you are not a citizen of the United States. You are a citizen of XYZ country. You enter the United States on or before so date with authorization to remain until so date. You remain in the United States beyond the period authorized in violation of Section 2 of the immigration law. Usually that is the way the NTA comes. So the judge will ask you, how do you want to plead to those allegations? If you look at the way those allegations are drafted, usually they put a respondent in a position not to be able to deny the allegations. If the NTA says you are not a citizen of the United States, that's not something you can contest, so you have to admit. If the NTA says you are a citizen of so country, usually they will have checked your passport, your visa, the country where you came from. But if the NTA is wrong, if for example you are a citizen of Mexico and the NTA says you are a citizen of Guatemala, you can deny the allegation. You can say, well, Your Honor, we deny allegation 2. The respondent is not from Mexico. You deny it. But if the allegation is right, then you admit the allegations. Now, after that, the charge, usually the charge is unlawful presence or overstay, or in some cases, unlawful entry if you did not come in legally. So that usually those are the charges. So again, if you have been here unlawfully, if you have overstayed, you have no choice. You will have to admit to the charge. Now, after admitting to the allegation and admitting to the charge, then the judge will ask you, what relief are you seeking? Remember, when you are filing your motion to reopen, you have to indicate your relief. So now it will be an opportunity for you to present your relief to the court. So you present your relief, and then the judge will give you a deadline. Okay, submit your application for relief on or before so date. The court can reset the case for another individual or for another master. Or if your relief is already ready and maybe you already attach it to your motion to reopen, you can just tell the judge that, well, your relief has already been attached, your relief is already in the presence of the court, and that you are ready for individual hearing date. And then the court will set the case for individual hearing. That is the date that you will have the opportunity to present your case. And if you present your case, the judge agrees with you, then the judge will grant your relief. And of course, if the judge disagrees, then the judge will deny your case. So that is what will happen if your motion to reopen an in absentia order is granted. Another question. I filed a motion to reopen my in absentia case. The court reset my case, but it is in 2026. Is there a way I can move the hearing up? Yes. I'm assuming that this person does not have a lawyer, because if you do, I mean, your lawyer should have told you. All you need to do is to file a motion to advance hearing date. You file a motion to advance hearing date. But normally, the court will not advance it if you do not have a relief. So usually, it is either you have a relief that has either a petition that has either been approved, or maybe a relief that you want the court to consider timely. So yes, you can always file a motion to advance hearing. So once you file it, the court will probably advance your case. But in some cases, you can file a motion to advance hearing and the court may deny it. I've done that before, especially that was during COVID. I filed multiple motions to advance hearing that were denied by the court. The court keeps saying that they don't have any earlier date. But most of the time, the court will grant it, especially a long date like this, because 2026 is still a long date. This is still 2023. But let me also give you a word of advice. Before you file a motion to advance a hearing, look at your options, because sometimes a long date may be beneficial to you. Look at your option, because I've seen clients who are desperate. They want their case to be done as quickly as possible. Meanwhile, they have a very weak relief. Sometimes, depending on the circumstances, sometimes a long date may be giving you an opportunity to have a new relief that you previously didn't have. A long date may give you an opportunity. For example, maybe you have been here for 7 years. You didn't meet the requirement of cancellation of removal for non-permanent resident. Even though the issuance of NTA, notice to appear, has actually stopped the clock. But I tell you, if your case is continued for 3 years and you end up being here for 10 years, although the NTA has stopped the accrual of the clock, we can actually, in some cases, you can actually talk to DHS for them to withdraw the NTA and issue a new NTA that will have a current date. DHS usually will do that if they believe that you will be eligible for cancellation of removal. If your qualifying relative has a condition that is positive for the purpose of cancellation of removal. God forbid, let's say your spouse is diagnosed of cancer. I can guarantee you that DHS will probably agree to reissue the NTA to give you the opportunity to apply for cancellation of removal, especially if you are the primary caregiver to that spouse. So, review your case very well. Sometimes it may be in your interest to leave the long date. Consult with an experienced immigration attorney if you don't have one. A word is enough for the wise. I hope to see you again. This is every Wednesday. Join us 12 p.m. Central Standard Time, 1 p.m. Eastern Time, 10 a.m. Pacific Time, 6 p.m. Nigerian Time, every Wednesday. Remember to join us. Thank you. Again, before I go, join us at the RCCG North America Convention on Friday, June 16. RCCG North America Convention in Dallas on Friday, June 16. We will be having a session. We will be having a breakout session. Join us. There will be lawyers from our office in that place. We have Attorney Olu Asekun right there. You have Marisa on ground that day, and you also have Kimberly on that day. And I will also be available either electronically or otherwise. But join us on Friday, June 16 at the RCCG North America Convention, where we'll be having a breakout session to discuss immigration matters. Thank you. God bless you. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on. And I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved. And I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face, and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, you know, Nigerians, you know how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another
principle was that it was a man that you can rely on. They work with me, you know, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody you are providing you service, right? So it became something like a family. So yeah, I can see the relationship was good, working with his staff. People give me encouragement, but I will look at it and say, how is it possible? You know, I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But him, he knew what he was doing. Like I said, research is very, very important. You know, if you do research, you will learn a lot of stuff. You know, there are a lot of immigration rules some people don't look at. You know, there are loopholes there, and sometimes they purposely put them there. You know, so it's research, and he's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here that, many people here that he has helped. Many people. Sometimes it doesn't even charge them. You know, when it comes to the point that it doesn't even charge them. You know, so yes, if you are looking for an immigration lawyer, you know, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, you know. I will say it, Dr. Asekun is there, you know, I will just say it. So, yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have. My first impression was that it was a man that you can rely on. They work with me, you know, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody you are providing you service, right? So it became something like a family. So yeah, I can see the relationship was good, working with his staff. People give me encouragement, but I will look at it and say, how is it possible? You know, I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But him, he knew what he was doing. Like I said, research is very, very important. You know, if you do research, you will learn a lot of stuff. You know, there are a lot of immigration rules some people don't look at. You know, there are loopholes there, and sometimes they purposely put them there. You know, so it's research, and he's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here that, many people here that he has helped. Many people. Sometimes it doesn't even charge them. when it got to the point that doesn't even charge them, So, yes, if you are looking for immigration lawyer, even if I'm sleepy right now, if I'm like sleepy, you wake me up